Section 120, parties to the civil suit and their wives are husbands. Husbands are a wives person in a criminal trial. In civil proceedings, parties to the suit are competent witnesses. Husband and wives are competent witnesses for or against each other in civil as well as criminal proceedings. Parties in civil proceedings are competent witnesses, and therefore their testimony is to be scrutinized in the same manner as that of any other witnesses. There is no inflexible rule that if a party gives his testimony, he must be disbelieved because he is a party to the suit. In Eden versus State of Rajasthan, it was held that truthfulness of the statement of a wife could not be disbelieved merely because her emotional reaction was different from what it should have been in the opinion of the court. The husband was his wife's power of attorney. In that capacity, he had made a statement on behalf of a wife. The wife wanted to examine him as a witness. The court said that in spite of the suit between them, they continued to be man and wife. Whether the evidence of the husband was useful or not in deciding the matter between them would be decided at the stage of judgment and not at the stage of a recording evidence. Plaintiff brought a proceedings against B in a Watford Country Court and against D in Brentford Country Court, alleging unlawful eviction in both cases. B, in support of his application to strike out the proceeding, swore an affidavit raising serious allegation against the plaintiff concerning the proceeding. The affidavit was made available to D to assist her in her own application to strike out the plaintiff's claim against her. The plaintiff subsequently sued B for damages for libel and slander, contending that defamatory statement contained in the affidavit, when used by D, were not protected by privilege. The court said that the test for deciding if absolute privilege attracted to defamatory remarks made in a witness statement used in a court proceedings is whether the statements are made with reference to the subject matter of those proceedings. There is no dispute that the test was satisfied in respect of the use of defamatory statement in the Waterford proceedings, for which B's affidavit was originally prepared. Equally, as the affidavit included allegation referring to other cases involving the plaintiffs, including his claim against D, the statement had a direct reference to the Brentford proceedings, and thus absolute privilege applied, particularly as it was clear that the material was published to D to assist in the ongoing proceeding against her. The failure as the part of the defendant to step into the witness box to make statement on oath in support of the pleading set out in the written statement led to an adverse inference, but the court refused to decree the suit of the plaintiff on the basis of pleading only. There was no independent evidence. Under section 121, judges and magistrate. Under this section, judges or a magistrate shall not be compelled to answer a question as to his conduct in a court such as a judge or a magistrate, or anything which came to his knowledge in a court as much judge or magistrate, except upon the order of a court to which he is subordinate. He may examine as to other matter which occurred in his presence while he was so acting. Section 121 to 132 declare exceptions to the general rule that a witness is bound to tell the whole truth and to produce any document in his possession or power relevant to the matter in an issue. They deal with this privilege of certain classes of witnesses. The privilege given by this section is the privilege of the witness, that is, of the judges or a magistrate of whom the question is asked. If he waives such privilege or does not object to answer such question, he does not lie in the mouth of any other person to assert the privilege. Privilege of the judge or the magistrate extends only to his own conduct in a court as such judge or a magistrate, or as to anything which came to his knowledge in a court as such judge or a magistrate. A judge before whom the cause is tried must conceal any fact within his own knowledge, unless he be first sworn, and consequently if he be sitting with the others, he may then be sworn and give evidence. In this last case, the proper course appears to be that the judge who has thus become a witness should leave the bench and take no further judicial part in the trial, because he can hardly be deemed capable of impartially deciding on the admissibility of his own testimony or weighing it against that another. A person having to exercise judicial function may give evidence in a case pending before him, when such evidence can and must be submitted to the independent judgment of the other person exercising similar judicial functions sitting with him at the same time. Where a judge is the sole judge of the law and fact, he cannot give evidence before himself or import matter into his judgment not stated on oath before the court in the presence of the accused. The accused is entitled to have nothing stated against him in the judgment which was not stated on oath in his presence, and which he had no opportunity of testing by cross-examination and rebutting. If the judge knew any facts concerning the case, he is bound to state to the accused, so far as he could, what were the facts he himself observed, and to which he himself could bear a testimony. And the accused in such situation has a right, if he thought it desirable, to cross-examine the judge, whose evidence should be recorded and form a part of the record in the case. The privilege extends to arbitrators also. In no case an arbitrator can be summoned to explain how he came at his award. Under section 122, communication during the marriage. This section rests on the obvious ground that the admission of such testimony would have a powerful tendency to disturb the peace of the families, to promote domestic broils, and to weaken, if not to destroy, that feeling of mutual confidence which is the most endearing solace of married life. The protection is not confined to cases where the communication sought to be given in evidence is of strictly confidential character, but the seal of the law is placed upon all communication of whatever nature which pass between husband and wife. It extends also to cases in which the interests of a stranger are solely involved, as well as those in which the husband or wife is a party on the record. It is, however, limited to such matter as have been communicated during the marriage. This section limits the rule enunciated in a section 120. The expression implies that the party concerned is made or allowed to say or to do something by way of disclosing a communication made during a marriage. Thus, a wife was not allowed to tell what her husband told her about a murder which he was charged. A document, even though it contained a communication from a husband to wife or vice versa in the hands of third person, is admissible in evidence. For in producing it, there is no compulsion on or permission to the wife or a husband to disclose any communication. The section protects the individuals and not the communication if it can be proved without putting into the box for that purpose the husband or the wife to whom the communication was made. The marital communication can be proved by evidence of the overbearers. The confession to wife in the presence of others was allowed to be proved by others. Letters written by husband to wife were held to be provable otherwise than through wife. Where there is no representative interest who can consent under this section to the disclosure of communication made by deceased husband to his wife during a marriage. The wife should not be permitted, even if he is willing, to disclose such communication. The widow of a deceased husband is not this representative in interest for the purpose of giving such consent. Under section 123, evidence as to affairs of a state. These sections involve two things: that the document is an unpublished official record relating to any affairs of the state, and that the officer at the head of the department concerned may give or withhold the permission for giving the evidence derived therefrom on a ground of public policy. Evidence derived from an unpublished official record of a state cannot be given except with the permission of the head of the department concerned. The court is bound to accept without question the decision of the public officer. Section 122 prevents communications between a man and his wife from being disclosed. Marriage inspires confidence, and confidence inspires openness of a heart and feelings. This enables the married person to make a clean breast of everything to his or her spouse. Naturally, therefore, such matter should be free from the risk of being disclosed. Policy of protection is thus stated by an American judge. Communication अरे हे उदे ना बाबा 120 झालं ना. The policy of protection is thus stated by an American judge. Communication and transactions between husband and wife were early recognized as privilege, and neither could be compelled to disclose what took place between them, and neither they could be compelled to disclose what took place between them, and neither was a competent witness to testify to such transaction or communication of a confidential nature or induced by marital relations. From experience, it was found that far less evil would result from the exclusion of such testimony than from its admission. It may, in individual cases, work hardship, but the destruction of a confidence between a husband and wife would cause much misery and affect the marriage relations. This rule is founded upon sound public policy. Those living in the marriage relation between not compelled are allowed to betray the mutual trust and confidence which such relations implies. The only ground sufficient to justify non-production of an official document marked confidential is that production would not be in the public interest. For example, where disclosure would be injurious to national defense or to good diplomatic relations, or where the practice of keeping a class of document secret is necessary for the proper functioning of the public service.